And please identify with who you're with. Name and who you're with.
Thank you. Peggy Orchowski. I'm a congressional journalist for the Hispanic Outlook, and I cover immigration. And before I ask my question, I really need to clarify that as immigration journalists in Congress, we cover all sides. We do not refer to people who want immigration laws enforced as being anti-immigrant. We don't refer to people who support sanctuary cities as being pro-immigrant. And we do refer to people who are supposedly undocumented but often have false documents, fraudulent documents. We refer to them as illegal immigrants. So I just wanted to clear that up as a member of the press club. My question is, as I understand the Culbertson letters, it refers mainly to convicted felons who have served their time, know that they're going to be deported, their families know they're going to be deported. This is no surprise that everybody knows at the end of their sentence that ICE is to come in and secure them. And yet for some reason they say, no, we're not going to let them be deported, we're going to release them. So I don't know how you can defend not continuing with the sentence that is unique to illegal immigrants, but they are convicted felons.
Well,
I don't understand.
look, I think it's very important to recognize that we support enforcement of immigration law, of people who are convicted of crimes that are listed as being resulting in deportation, and if there's no relief from deportation for those folks. The problem with the Secured Communities program as it existed is it was not focused at the conviction end of the process. It was focused at the arrest end of the process. And someone who's arrested and charged with a crime, or even worse, if you look at some of the statistics, they say they're compiling together detainer requests that were refused for people who were convicted, arrested, or suspected of criminal activity. So what we have seen in communities, our members report to us that what will happen is an individual will get tagged as a suspected gang member and will then be subject to a detainer order from immigration because the criminal authorities don't have anything to charge them with. Instead, they say, let's use immigration instead and just get this person out of our community. Well, it's really using immigration law in lieu of criminal law, against someone who they can't prove a case for. We saw this after 9/11, where individuals were rounded up with immigration violations and were flagged as suspected terrorists when there was no evidence of whether they were a terrorist or not, but they would be detained under the immigration authority so that they could be interrogated, for example. So,
may I just add?
Yes. No, go to the microphone, please.
Again, it's not the prerogative of state and local governments to decide which illegal aliens or criminal aliens are going to be subject to deportation. The Constitution has given Congress that authority to decide, and ICE is executing that responsibility. You simply cannot substitute, the states and municipalities cannot decide which illegal aliens are going to be deported. It's simply not their call, whether they're criminals or not.
Okay, other questions? Sir?
Well, my question is for both of you. My
Sir,
name is Steve.
Name and organization.
Yeah, I was just going to give you that. My name is, my question is for both of you. My name is Steve Cameron. I'm at the Center for Immigration Studies. So, just so I know both of your positions, if somebody is arrested for drunk driving or doing something, and then the local jurisdiction doesn't hold them, but say when we had, doesn't charge them, but Secure Communities had shown this person is clearly illegal. They had crossed the border illegally and were fingerprinted, and the fingerprints match. Your position is, look, they don't have to hold him. This person is unambiguously in the United States illegally. The Immigration Service asks them to hold him, and you're saying, no, he's got to be a violent felon who's previously been convicted. How is that different than open borders? We have an authority has arrested, the person's been identified as an illegal alien. Why would we ever release that person? I think most Americans say, well, we don't want the police rounding people up, but what would both of you say? That person should be deported and the jurisdiction should hold them, even if they haven't actually killed someone or committed another serious crime. Either one of you.
Who wants to go on? You first and then you.
Sure. So the first thing I would point out is that the founders of this country understood that the physical detention of any person was the most coercive power that the government has. And it should only be exercised under the supervision of neutral magistrates. They enshrined the privilege of habeas corpus, being able to go in front of a judge and hold that your detention is unlawful, in the Constitution, that it could not be suspended except in cases of invasion or civil war. So what we are talking about is the requirements for physical detention of any person in the United States, that it be done lawfully. And one of those requirements is that any detention be done only upon probable cause upon showing to a neutral magistrate. When an immigration service officer requests an individual who the immigration officer suspects is an undocumented immigrant because they've been notified through a fingerprint check, they don't have to prove that to anyone. In fact, that foreign national may not even be subject to any kind of post-detention review of their status for weeks or months. This term, the Supreme Court will decide whether or not the constraints that they said were lawful on detention of people during the immigration process, whether those have been exceeded over the last 10 years since they made their first decision. All right, because that coercive detention power is the power of the government that the founders most feared, they required that it be exercised within strict constitutional limits. That's why I think cities which say, Immigration Service, please get a warrant, show a neutral magistrate that this person is subject to your jurisdiction, are upholding the Fourth Amendment to the Constitution.
Well, again, the solution that Bill has suggested is just neither required under the law nor practical. What we're talking about is people are getting arrested. It is discovered that they are here illegally or potentially deportable through a fingerprint match or through an interview in a jail. ICE issues a detainer. That detainer has an indication that ICE has probable cause to believe that this individual is deportable. That's not even the standard. The standard is articulable facts. This is not a criminal case, so there are no trappings of the criminal system. There are no magistrates available who could even provide the blessing that he's suggesting. All that Congress has decided that ICE needs is articulable facts that the person is deportable, and that the state or local law enforcement agency shall maintain custody of that alien. That's what the federal regulation says, shall maintain custody of that individual for ICE, just as they would do for any other law enforcement agency, up to 48 hours. Usually ICE gets there much quicker than that. The state and local governments get reimbursed partially for their costs already through a federal awards program. And again, we're talking about people who've already been arrested that sanctuary policies would rather release rather than have them be sent back to their home country where they can no longer prey on individuals in the community.
Okay. Here and then Matt, sir.
Yeah, my name is Sector Correa. I'm with Mexican American Legal Defense and Educational Fund. I had a question about a statement you just made, ma'am. You mentioned that this is not a criminal case. So I want to ask you, why is it that we are holding these suspected undocumented immigrants in detention if this is a civil matter? And can you note any other instance of federal civil laws requiring people being detained before being given due process?
Sure. And again, it's not just that they're suspected of being here illegally. The ICE officer has to have articulable facts and is stating that they have probable cause. And often, the identity is matched through a fingerprint, so they know what they're doing. Those are the individuals that are being released by the sanctuaries. And the reason that they need them held in custody is because ICE can't be in every jail, in every courthouse, patrolling the streets looking for criminal aliens. When they are notified that a criminal alien or an illegal alien that they want to deport is in someone's custody, they're asking for them to be held in custody in accordance with federal regulations and in accordance with the law that Congress has written, which determines what that due process will be. So.
Matt, and then,
Yeah, this one's for Jessica too.
Matt, please identify.
Okay, Mel Klein, Accuracy in Academia. The $50 billion drain, where does that number come from? What does it include?
The $50 billion a year is the net drain on public coffers. The difference between what illegal aliens are estimated to have paid into the system in taxes and fees and so on, minus what they are estimated to receive in welfare benefits, educational services, housing, healthcare, and all the other array of publicly funded services that are made available to them. So it's a net cost, it's the difference.
And I would just point out that you get that net cost by putting the costs that are attributable to U.S. citizen children onto the foreign nationals, but revenues from the U.S. citizen children as they grow up and become taxpayers on the U.S. citizen side. So that math only works if you count the U.S. citizen children as costs when they're children, but as benefits when they grow up.
Okay, other questions?
Hi, Shelby Ostergaard for The Wire. How does the lack of a legal definition of sanctuary cities affect the debate that you guys have, especially when you're talking to people who are maybe not so well versed in immigration law?
I think it's very critical that we have some sort of understanding of what we're talking about when we label something sanctuary cities. There is no accepted legal definition of what a sanctuary city is. Right now, Section 1373 says that no state policy can prohibit communication between state officers and the federal government with respect to immigration. That's fine, but it doesn't answer a far more important question, which is, does Mayor Jim Kenney want Philadelphia police officers spending time and resources finding out information about immigration status in the course of enforcing the law? So those, I think we have to define. In 300 jurisdictions, you're going to find 300 different definitions of how they cooperate or don't cooperate. So we don't have an idea. And sanctuary cities is a label that's applied to try and argue that these are cities who are somehow shielding immigrants, when in fact, what they're doing is simply requiring the federal government to do its job.
There's definitely a spectrum of sanctuary policies across the nation, and it may mean different things to different people, but our definition of a sanctuary jurisdiction is any government that has a policy, practice, ordinance, rule, or law that actively obstructs immigration enforcement or shields illegal aliens from federal detection. And there's even a spectrum of policies within that. But I would disagree that there is no legal definition because, again, as we've discussed, 1373 does say that no government can in any way restrict communication. Another part of the law, 1324, says no one may harbor or shield from detection criminal aliens. So, I mean, I agree that this is evolving, but I think we do have a standard, and ICE knows which jurisdictions are not cooperating. And so, no one is saying that cities shouldn't have a policy that's welcoming to immigrants. The issue is when it crosses the line into obstructing the legitimate enforcement of immigration laws.
Other questions? Any other questions? If not, I think we owe both speakers a round of applause. And we especially want to thank the audience here. You've been wonderful.